for there to be close coordination. But I think this executive order express what we all assumed. The next executive order that, if you haven't taken a look at, will affect RMP rulemaking is Executive Order 14008 or 14,008 on tackling the climate crisis. It's signed again a few weeks after President Biden came into office. It created the WEJAC, the White House Environmental Justice Advisory Council. They're starting to have public meetings. We've had people on our team dial into those, and they last a long time, 3 or 4 hours. But that council will be creating some environmental justice tools like advanced modeling or new modeling. And this executive order directed EPA to strengthen environmental enforcement as a targeting consideration in its existing programs. And it directed DOJ to create an Office of Environmental Justice to look across DOJ components, not just the Environment and Natural Resource Division, but all DOJ components to see how environmental justice could be better served. And then the final piece of it is that there is going to be a formal environmental justice enforcement strategy that will address what the administration perceives to be burdens disproportionately placed on underserved communities. So again, this is something that we would expect regardless of the executive order, but the executive order from a bureaucratic perspective, it makes this a box that folks at DOJ and EPA are going to have to check as they go through RMP rulemaking. And I think most important, short-term enforcement, we'll talk about this, but from a timing perspective, regulations take years to develop. Enforcement is something that is much more nimble. There are always many more cases that EPA and DOJ could bring than there are resources and people. So there's a high degree of what's called enforcement discretion when EPA decides to pursue a case. Environmental justice will be an important consideration for EPA in deciding which cases to pick. Right, that leads us to the next topic, which is the RMP rulemaking. And before going into what this administration has announced its intentions are, I think it's really important to have a historical perspective on what's taken place in President Obama's administration and President Trump's administration. I sneaked a peek at some of the people participating today. There are some familiar names who have been in the trenches with us and with AFPM as we've gone through this process in the last two administrations. But I think it's worth reflecting on what happened in the past and see if it could affect the future. As one philosopher once said, past can be prologue. So let's think about this right here. This is just a timeline of what happened in in President Obama's administration. I think you may recall that there was an incident in a West Texas facility in West Texas in 2013. As a result, President Obama issued an executive order on improving chemical facility safety and security. Then in 2014, EPA issued, it was almost in what I would call an advance notice of proposed rulemaking, where they had some thoughts on RMP, but it was styled a request for information. That led a couple of years or 18 months later in 2016 to propose RMP amendments. I think AFPM played an instrumental role in that regulatory process. We worked very closely with many of you on this call, with Laura, and we wrote very detailed comments. I think at one point, when I counted this, it was 160 pages of comments with hundreds of pages of exhibits, because we had a lot to say. We did a lot of in-person meetings. We filed those comments. The rule itself was not finalized until January 13th, 2017. It was a midnight regulation done right before President Trump took office. Now, immediately following that, we worked with AFPM, ACC, the Chamber of Commerce, I think API, NAM, and formed an RMP coalition and filed a petition for reconsideration. That was granted, and as a result, we received a 90-day stay of the RMP amendments effective dates until June 19th, 2017. Then if you look at that, there was there was, again, another delay. EPA came out with a rule in June 14, 2017, delaying the effective date until 2019. However, that delay rule was vacated by the DC Circuit in 2018 in an opinion that we were involved in the case as interveners, and an opinion that I shall say was, I think, decided based on who was in the panel. And if you ever have a chance, please do read that and think whether it was fair what happened, because the judges and Earth Justices urging renamed the RMP rule the Chemical Disaster Rule, which I had not heard that before, but it's written in opinion by at least 2 federal judges. What happened after that is EPA in earnest began trying to reconsider the RMP amendments, which happened right after the elections in December 19th, 2019. So why did I go through this long list? And then because I think it informs what's going to happen now. There will be a push, and we'll get into the substance of this, to reinstate some of the RMP amendments, including inherently safer technology, third-party audits. But as we think about that timing on this slide for the RMP amendments, the sequel, I think we have to think back to the prior 2 slides of how long did it take President Obama and President Trump to get through these issues. And particularly in the last administration, Stephen Cook, who was at LyondellBasell, excellent project manager, excellent lawyer, really knows process safety from both an industry and I think a compliance perspective. It took quite a while to get through this. So let's keep that in mind as we talk about the timing for the RMP amendments, the sequel. I think many of you are aware that EPA had listening sessions on June 16th and July 8th of this year on the RMP amendments. And again, I mentioned the executive orders at the top of the presentation on climate change, et cetera. Those are expressly cited as a reason to have those RMP listening sessions. In June of this year, the DC Circuit placed in abeyance, meaning it stayed, any of the challenges that the NGOs, the unions, and the blue states had to the final reconsideration rule, repealing the RMP amendments. So that litigation is on hold while EPA goes through the process for coming up with the RMP amendment sequel. OMB, the Office of Management and Budget, has published a schedule that says EPA is targeting September 2022 of next year for proposed RMP amendments. And then EPA is targeting August of 2023 to finalize the RMP amendments, the sequel. And here's sort of the key questions as we think about those amendments, just in terms of timing. I think the first one we've talked about is 2023 realistic for a final rule. I'm going to go out on a limb here and not be a hedgy DC lawyer and say, no, it's not realistic. I think it's more likely it will happen in 2024. I think that conforms more to what we've seen in the last 2 administrations, that it really takes almost a full term to digest and work through an RMP rulemaking, whether that's proposing new amendments or rescinding them, as was done in the last administration. So that would really be my first thought there. Political leadership, I think this is very important to think about from both an RMP rulemaking perspective and enforcement. On the rulemaking perspective, the administration has nominated a gentleman named Carlton Waterfield, a law professor who formerly served at EPA in a career legal position, to be the head of OLEM, the entity within EPA that's in charge of RMP rulemaking. That nomination was scheduled for a hearing earlier in this month. I think the hearing was pushed back because there was some controversy about earlier remarks Professor Waterfield had made about the defund the police movement. I have not heard further whether that is going forward. My only point there is that the uncertainty around the political leadership, if that continues, it could certainly affect the ability to get that rule out on time, because without a political appointee and assistant administrator, some of these things can tend to lag. The other point here is thinking about litigation as we go through this RMP amendment process. I think there was Definitely in the last administration, President Trump's administration, some surprises in terms of the litigation. We had some effective dates spring into being from the RMP amendments during the rescission process. So I think it's both inevitable that there will be litigation, and it's also, I think, prudent to look at alternative scenarios when considering litigation, meaning I wouldn't bet one way or the other on how the litigation would come out without knowing anything further other than to advise management, yes, it will be out there, and it's an uncertainty we all need to consider. So that's really the substance in the process. What can we expect? Pardon me, that's really the process. But what can we expect from the substance of the RMP amendments, the sequel? I think first, you're going to see some heavy borrowing from the original RMP amendments. There will be a reinstatement of third-party audits. I like to be careful and caveated when giving advice or counsel, but I think this is largely a certainty. You recall last time third-party audits were targeted at facilities within certain NACE codes. I think it was pulp and paper refining and chemical manufacturing. And then based on whether there'd been an incident within a certain amount of time, the third-party audits had to be conducted and provided not only to the company, but to the board and the agency. Imagine the kind of reaction that might get if you're regularly having to go to the board on a third-party audit, RMP audit. So in any event, I think that is something that it's a near certainty it will appear in the RMP amendments, the sequel. And we'll talk about some ways that the trigger for the third-party audits might be changed, the scope of the third-party audits might be changed, but as a concept, it's going to be in there, and it's remained really. This is an important point. You'll frequently see in enforcement settlements of RMP some elements such as third-party audits that are being considered in rulemakings. I think some would reasonably criticize that as regulation through litigation or enforcement. Be that as it may, from a descriptive perspective, not a normative judgment, it's reasonable to expect third-party audits in not only the rulemaking, but as part of the enforcement process. The second one that there is a very high probability we'll see again is safer technologies, alternative analysis, or inherently safer technologies. You recall again that the trigger for that was placement in certain NACE codes that I've already mentioned, for pulp and paper, refining, or chemical. And you also recall that in the original RMP amendments, it was styled as a process requirement, meaning that substantively, if you evaluated a process unit and found that there was inherently safer technology, it didn't compel you to switch to that inherently safer technology. But in the response to comments for the original RMP rules, EPA said that it could take into account your failure to implement IST if there was an issue later on under the general duty clause, meaning general duty to minimize releases under 112R. The interesting thing about this issue is that I think for new greenfield facilities, folks already do IST. There's some industry guidance that says it's essentially a good practice. The real controversy was over existing process units and whether they had to be implemented. And then I think there were some different voices in the industry in terms of how much an effect this has in the jurisdictions where it currently exists as a matter of state law, specifically New Jersey and Contra Costa, California. Be that as it may, we are going to see that again. The next one I think is likely. I don't know that it's as certain as IST and third-party audits, but we're going to see another attempt to have a more prescriptive root cause analysis methodology for incident investigations. And I think every company we work with, I think every company I've ever talked to, everyone does a root cause analysis. If there's an incident, it's good practice. There's a lot of reasons to do it, both legally and practically. I think the concern that the regulated community had the last time around was just that the methodology in the rule was prescriptive. It seemed contrary to RMP being a performance based standard, and one that has secured tremendous improvements in safety. So one of the controversial issues that we are likely going to see again was that there was some root cause analysis triggers for near misses, and then there was a debate between the regulated community and EPA of what near misses meant, whether it was required, et cetera. Be that as it may, we're likely to see this again, although just to reiterate, not as certain as IST and third-party audits. All right, here's where we're going to see some new twists. I think, and again, these twists really should be viewed through the lens of climate change and environmental justice, as we talked about at the top. And there are many publications out there predicting what this could look like. I think the best one to look at, and I don't mean the best in terms of the policies proposed, but the best preview you can get for all these new twists is a report that came out last month from Earth Justice, the Union of Concerned Scientists, USW, et cetera, on how RMP could be amended to address climate change and disasters resulting from climate change. I'm happy to send that to you after the presentation. I didn't want to append it to my presentation and therefore adopt what I think are some seriously mistaken policy ideas by Earth Justice and the other folks in that report, but it does give you a good preview where the Earth Justice, USW, et cetera, want to go. And I think the first thing is just incredibly expanded community engagement. I think most facilities all have community engagement programs. There's various consultants who actually have this as a practice. And I think in the last administration, there were some attempts to limit, as an example, public meetings after incidents, so only to those that have offsite impacts. I think there's going to be a broadening of those types of post-incident public meetings, and it's just something that we can expect to be out there. I see we have something from the chat. Oh, yep, and AFPM put the report into the chat, even better. So I commend everyone to take a look at that. The next one is very much important. This is climate change risk prioritization. This is literally taking every program element of RMP and PSM and integrating worst case scenarios based on climate change. So, and as an example, this Earth Justice report wants to have third-party audits, not a surprise, but not only would they look at your typical program elements, but they want specifically third-party audits on facilities, preparedness for natural disaster planning, and for climate risks. Is this in an area where there are 100-year storm events? Do you have enough natural gas generators, et cetera? Offsite consequences analysis, also looking at potential climatic impacts, accident history, all existing program elements and all the new program elements that we're likely to see in an amendment. They want to make Earth Justice, USW, et cetera, want to make climate risk baked into that. Again, another area where we're seeing, where we're likely to see a serious push is what I'll call EJ risk prioritization. And what does that mean? That means looping the community much more tightly, I think, than many facilities have into what is going on at a facility. And this, to me, it almost is not a great fit with RMP. Some of the ideas here are to have fence line monitoring, which, thinking about EPA Section 112R of the Clean Air Act and EPA's existing regulations of practice, I'm not sure how that would fit in, but also tying those fence line monitors, text alerts, and some other things. And I think for both EJ and climate risk, the biggest issue we're going to face is just an expansive view of RMP applicability. I think most people know you have to have an RMP process unit, meaning having some regulated substance of a threshold quantity in a unit to make it an RMP covered process, and it applies to that covered process. When you read this report that's been put in the chat, I think it's maybe the third or fourth recommendation from Earthjustice et al., but it's really to expand RMP applicability in a way that makes it almost all-encompassing. So they want to make, the NGOs want to make all flammable and explosive chemicals part of RMP, and they want to have basically a rule that says if one process unit at a facility is covered, the entire facility is covered. And you may recall in some of these battles back and forth over the regulations in President Obama's administration, President Trump's administration, there were arguments that industry made that said, well, West wasn't truly an RMP incident. The other one that was brought up were some facilities that were involved in Harvey, that those weren't RMP incidents. And I think the NGOs have taken those criticisms and said, yes, exactly, they should be. The final piece of this, I think, is just making sure communities, in their view, are ready for incidents. They want to do things like invest in PPE for communities and give them real-time monitoring data. So what does this mean immediately? I would say it's, as I said, going to take years for this rule to come out. But I do think EPA is going to use EJ screen as a way to look at what communities are potentially have facilities that ought to receive additional attention. And here's just a screenshot of EJ screen. And here's a more speciated look at it. And it looks at a variety of socioeconomic factors and also pollutants to determine how much burden a community has. So I could see the agency using EJ screen or this new model that the White House Council on Environmental Justice is developing, not only to deal with these community engagement, climate risk, and EJ risk prioritization, but I could also see them using these models to create additional or different triggers for third-party audits or IST. So in other words, if you're in a facility, if your facility scores high on EJ screen, you could, for example, have to do more third-party audits than a facility that does not have a high EJ score. So that's something I think we need to think about as the regulated community and thoughtfully engage with the agency, because talking to them and what we're hearing is this is definitely all fresh in their minds and something they're considering. That leads us to the final, or second to final topic, enforcement. And think of this as more of the near-term risk. Rulemaking, again, it's going to take years. It's incredibly important to be engaged through AFPM on this topic. Laura and her staff have done a tremendous job of talking to Jim Belkey and other folks at EPA. And I just think we need to be engaged early and often, because as we go through this process, some of these early ideas can get their own inertia. We want to be able to have a voice in the room. But that said, enforcement is more of a near-term risk, and it's somewhat more difficult to manage because traditionally it's not something that trade associations engage on. And the way the agency approaches it, they tend to come and enforce on a company-by-company basis, which can lead to a lack of clarity on what exactly is going on. But we'll try to provide some of that. So let's look at RMP enforcement. I think the first statistic is just by the numbers. For folks who are experienced in this area, it's not surprising. Like most EPA enforcement programs, the vast majority of enforcement is done administratively. So if you look at 2020, I just checked this again yesterday. I think there's roughly 74 administrative RMP settlements in one civil consent decree at a refinery for RMP. Looking ahead to 2021, we're into the third quarter. There's already 61 administrative settlements this year. And so and I should mention, when I use these years, I'm not talking about the fiscal year, meaning September to September. This is literally calendar year. So for calendar year 2021, we're through about 61 administrative settlements. At that rate, we'd expect to be a significantly higher number of enforcement settlements than 2020. There's no civil consent decrees. We're hearing there's some on the horizon. Now, most concerning though, there is a significant new indictment, and we're going to talk about that in some detail below. But that gives you just a sense what I think is a post election ramp up in enforcement on RMP, and it's something we consider likely to continue. What are some of the potential trends that we could see here? I think one that's a given, and I should mention, before I worked at Sidley and in another law firm where I worked for 10 years at the Justice Department representing EPA and enforcement. I was in the government service during President Obama's first term. So I'm familiar with this. I think we will see EJ models like EJ screen used for targeting in enforcement. As I said, there's many more cases that can be brought in enforcement than will ever be filed or pursued or investigated. So there has to be criteria or metrics to determine what to enforce. So in the last administration, as an example, I think Susan Bodine and the leadership at EPA said for state delegated programs such as stationary source air, we want the states really to take a lead on that. And we're going to focus more on federal programs such as mobile source enforcement against vehicles. In this administration, I think in contrast, one of the governing principles will be environmental justice. And so I think you will see EPA score facilities for EJ to see whether they should receive scrutiny. I think you will see EPA make decisions between whether to pursue cases based on EJ scores. And also, there is a new criminal enforcement memo from May of this year from Larry Starfield, who's the acting assistant administrator for the Office of Enforcement and Compliance Assurance, that talks about using EJ as a criminal enforcement organizing principle. It's gone so far as that Deborah Russell, who is the chief of the environmental crime section at DOJ, commented in a recent Environmental Law Institute seminar that the environmental crime section wants to be proactive in environmental criminal enforcement, which is, I think, in my mind, raises a number of questions, but be that as may, that's the environment we're operating in. I think the second trend we are going to see is more aggressive civil enforcement. And what do I mean by that? I think there is a feeling among the career staff that past RMP settlements, civil settlements, including consent decrees, have been too lenient. Representing companies that have gone through those, I have a different perspective. But again, the career staff believe that there needs to be more consequences for violations. And I think that's reflected in some internal reorganizations. Traditionally, the Air Enforcement Division at OECA, the enforcement arm of EPA, has not been involved in RMP settlements. They do every other kind of air case. They're going to get involved, if not already. So that, to me, and that internal reorganization is important because having worked with those folks and had them as clients, they are very much interested in the mission, and their mission, they believe, is to deter others from violations. So I think it's reasonable to see more onerous terms and consent decrees, whether that's additional third-party auditing or other things. We're going to see it. But one of the consequences of that, I believe, will likely be higher civil penalties. We traditionally have seen RMP civil settlements, even with worker fatalities, sub 7 figures. I think there is a reasonable possibility in this administration that for significant incidents with a fatality, multiple worker injuries, or significant offsite consequences like shelters in place or evacs, you could start seeing the penalties, or at least the demands, creep into the 7-figure range on a regular basis. So that is obviously concerning. I think it's something just to be prepared for, and it's something to talk to folks about so that there is awareness. The final piece of this, I think, is really important. For years, the Justice Department and EPA and OSHA have had a worker endangerment initiative for criminal enforcement, where there's been an emphasis on using the existing tools in the Clean Air Act and Title 18 to pursue cases where workers have been endangered due to process safety issues. The new political appointee to run EPA's enforcement office, OECA, is David Ullman. Mr. Ullman is a former professor at the University of Michigan, a law professor, but most important, he was the former section chief of the environmental crime section. He's written extensively about criminal environmental enforcement, including worker endangerment, and I think he's done some, in his career, some marquee cases against refineries, chemical plants, et cetera. So I think once he is confirmed, I think he's had his confirmation hearing, it should come in soon. You're going to see a real focus on this, and it's something, if you're taking notes at home, I would circle that in red. And I think this case is an early harbinger of where the administration might go. This is US v. DuPont. It's a January 2021 RMP indictment. This came out, given the lead time to develop a criminal or civil case, this obviously had to be worked on in the last administration. The indictment fell after this administration was inaugurated, but it's something just to keep your eyes on. Let's talk about this because it's fairly rare to see one of these, and the allegations just are of interest, I think, to the regulated community and something we just need to be aware of. So on January 19, 2021, the U.S. indicted DuPont and a former supervisor of their insecticide business unit at La Porte, Texas plant. When I say supervisor, if you read the indictment, this gentleman had, I think, about 34 people reporting to them, including some unit supervisors. The incident was a release of methylmercaptan from a unit that manufactured a pesticide, linate, and there was a blockage in the unit. The company tried to remove the blockage. As a result, there was a release. There were 4 worker fatalities, and there were some injuries to other workers. Interestingly, DuPont previously paid a $3.1 million civil penalty in 2018 for 4 violations: management of change, safe work practices, MI, and failure to develop written operating procedures. But again, this case illustrates there's a long tail on criminal environmental liabilities. You know, that was 3 years ago, and they still went forward with this indictment. The other interesting thing is there is an internal DOJ policy, if you look up in the DOJ manual, that discourages civil penalties when there's a pending criminal case because of double jeopardy concerns or how it could play in front of a jury if a company's already paid a large civil penalty. Notwithstanding that admonition in the DOJ manual, this indictment happened. The other interesting piece to me is that this unit was demolished, decommissioned. So where the incident took place, it no longer is there, which if you read the civil penalty settlement as a reason, it's not a consent decree. So it's a 3-count indictment of the company and the supervisor. And recall that I said there were 4 civil claims. 2 of those appear in the indictment as well, safe work practices and MOCs. And it really raises the question, why are these in a criminal indictment and not just resolved similarly? And the key phrase is in section 113C of the Clean Air Act for a knowing violation of the Clean Air Act. What does knowing mean? Well, I think it's easiest to explain what knowing does not mean. It does not mean knowing the law. Ignorance of the law is no excuse. It means knowing the facts that form the basis for the indictment. And here, the allegation in the indictment, and I should stress, all of these folks, both the company and the supervisor, I didn't even want to mention his name, are presumed innocent. The government has the burden to prove all these allegations by reasonable doubt. And I hope that the company and the supervisor prevail, but be that as it may, the government does not have to prove that the company and the supervisor knew the law, understood the RMP regulations. They have to prove is that the company and the supervisor knew the facts that are alleged in the indictment. So here, the indictment alleges that because of this blockage in the unit, it was well understood by the company that before you opened a line to clear the blockage, and here they would regularly clear the blockage by just draining liquids into a bucket or pumping some gas through, that there were certain steps that needed to be taken before clearing a line, including MOCs and an internal procedure on clearing lines or opening a line to the atmosphere, a line break, and that none of those were followed. So the indictment alleges that DuPont had clear and specific safe work practices and management of change guidance for this facility and for the company as a whole, but that the supervisor and the company did not follow those. In other words, they did not walk the talk. And as a result, 4 folks perished, and there were some other, I think a couple other injuries. That's the meat of the indictment. And again, you have to show that the company and the supervisor knew the facts. The other charge in the indictment is a misdemeanor for a negligent endangerment for putting someone at risk of imminent death or serious bodily injury. And it's common for the government to both charge felonies and misdemeanors. Because if there are issues in the case, the jury can always go for the lesser included offense. So what do you do for managing these new risks? What are some options? We talk to clients about this all the time. I think one thing to seriously consider about is EJ scoring your facility, just to get a sense of its risk profile. Particularly if you're a company that owns multiple sites, it will give you some sense of how to triage. I think the next piece of this is just educating management about these new RMP risks, both short-term, meaning enforcement, and long-term, the regulations. And it's never a comfortable conversation to say we face these new risks, we need to potentially change how we address the risks. But I think it's a conversation worth having sooner rather than later, because we're certainly seeing a ramp up in enforcement already. And I think when Professor Ullman takes his position as the head political appointee at EPA enforcement, see that even more. Another option to consider are doing your own third-party audits of RMP PSM. Certainly that can inform you of steps you need to take. There are audit privileges in certain states. There is an EPA audit policy. You can even e-file those now, electronically file them. So give some thought to that, and it could help you manage these risks. And then I think the final and most important point is just making sure you have a robust community engagement program. I think most companies have this, but it's always worth considering and challenging yourself. Is it enough? Looking at some of the headline cases so far outside of the RMP context that we've seen on EJ, there have definitely been allegations from EPA that the community was upset with the site, not engaged. And so I think it's important to consider. So with that, I will now open it up to questions and stop sharing my screen. So happy to take questions, either raising your hand, popping up on the screen, or you can put it into the chat.
Hey, Justin, thanks for that. Great overview of what's to come. If anybody has any questions, feel free to put them in the chat, or you can go on screen. I've got one. Are there any EJ audit protocols that a company could self-audit with?
That's a great question. The short answer is I've never seen that, but I think it's something worth considering about. Let's be real here. We went from there were a few people who did EJ screen and Cal EJ screen, and now there's a huge demand for services. So that's not something I've seen. That's actually an excellent idea of how you would go about doing an EJ audit. I've seen companies score themselves. I've not seen an audit. Sounds like something to work on, Laura.
Okay, I got another one. Who typically facilitates a third-party audit if a company chooses to opt for those?
Well, there's the company can do that. I think if it's a voluntary third-party audit, so if you decide, you know what, I want a third-party audit, you go out and you find someone who is good. It can be someone you've worked with. If it's a third-party audit under a consent decree or one of these RMP proposed amendments, there are going to be additional screening criteria. It can't just be, well, they're good. EPA has specific criteria for impartiality, meaning, and I forget in the prior rule, I think it was in the last 3 to 5 years, you couldn't have worked with that person. And to me, that has some downsides too. They're not familiar with the site. And there were also some qualifications written in the rule. But if you're just doing a voluntary third-party audit, right now, there are no requirements or obligations. If you want to have one that would qualify under the rule that we think is going to come by the end of the first term of the administration, I'd commend you to take a look at the criteria that were in the 2017 rule, which, as I said, include impartiality, your qualifications, and some other requirements.
Okay, how does EPA justify 180 turn in its position in RMP reconsideration rule, specifically IST and third party?
That is
going to be a 360 at this point, right?
Is this like the X Games? Is Tony Hawk on a 900? Yeah, I mean that's actually an excellent question. And there are some legal doctrines developed by our U.S. Supreme Court that give agencies flexibility to change interpretations or policy after an election. So the most famous one is called the State Farm case, and that's where NHTSA and the Department of Transportation kept changing its mind on airbags, going back and forth. And the court came up with some criteria that said essentially agencies can change their mind. They just have to consider all the statutory criteria, all the available evidence, and they can reach a different policy conclusion. I think more recently, there's a Fox News case that similarly held that agencies can switch course as long as they provide a reasonable explanation. And then it can include, we have different policy priorities as a result of the election. But this is really, really important, and it may not surprise you. Our last president, President Trump, was critical of the judiciary at times, including specific judges. I don't know if anyone has judges in their family or deals with litigation or courts. Judges tend to stick together. And so it's not going to surprise you that the last administration, President Trump, had a fairly high loss rate. I can't remember if they lost 60% of the cases or 70% of the cases where they tried to do a 180. And I think one hypothesis is that's just because President Trump, as I said, was critical of judges and he was constantly on Twitter and judges didn't like it. And so EPA unfairly didn't get the deference it deserves. And so maybe all those cases refusing to allow 180s under Trump, all those cases don't matter now. That was a one-off because of President Trump. But the other hypothesis is these cases, and these cases are at the lower courts, not the Supreme Court, really set some high bars for doing these 180s, both from a legal and policy perspective. So one hypothesis is, well, that might tie President Biden's hands because there were so many decisions coming out of the lower courts in the last administration saying, no, you can't change that, President Trump. So it's a really interesting legal question. And we're going to see in the next couple of years as President Biden tries to reinstate some policies and some rules, whether the courts are going to defer to that and follow these Supreme Court decisions, or whether they're going to follow the, dozens of decisions that would not allow President Trump to change regulations and policy. Hopefully that helps.
So to that end, can EPA use the same justification and support in the record that they did in the 2017 RMP? Or do they have to come up with new supporting evidence?
I think there would have to be new supporting evidence developed. I think one issue was the evidence is stale, so they're going to need to develop new data. I think the other issue is I have to give too many shout outs to Stephen Cook, the former deputy at OLEM and person who was at Lyndale-Bazell forever and AFPM member forever. But he did a good job of rebutting some of the rationale for the RMP amendments in terms of showing the efficacy of the existing RMP reg. So I think for those reasons, you'd have to do a refresh. But the most important reason is, again, this administration, everyone is going to be judged on what are you doing for climate change and environmental justice. So they're going to have to take the data they have anyway and see how they can mine it from those two perspectives.
Okay, so we got a few minutes left. No more questions, but I do have one more question. Like from an association perspective and preparing for RMP, we know it's coming. Slightly different twist with climate change and the weather, as that report, we posted earlier mentioned. What's the best way to prepare our arguments to lay, foundation for when, the proposed rulemaking comes out?
I think the most persuasive argument logically is the most challenging argument from just an emotional side, which is the existing rule works. I mean, we have all these safety professionals on the meeting, and there's really been a huge improvement in process safety since the RMP rules came on the books in '93. I thought Stephen did a nice job of explaining how that's continued. But from getting ready from an association perspective, and you do a terrific job of this, Laura. I think you just have to be aware of what the arguments are. If you look at this report that was in the chat, that is the blueprint, and then engage early and often and really provide data and analysis to knock down provisions that we don't think make sense, or if there are things that there's some things in the Justice report I thought, okay, this makes a little sense. Like, let's make sure there's in areas that English is a second language near sites, that there's bilingual, text warnings to folks if there's an incident. So I think it's that really getting engaged. And I feel like this is, what's that movie with Bill Murray where he wakes up in the same town it's like Groundhog Day. We have a schedule, this is what they're going to do. And so I think it's that and just really being engaged, but getting, we'd like to think in DC, we're at the center of the universe and all wisdom, but I think really working well, all the folks in this call and your members to understand what's happening in the real world and coming up with the data to rebut things that don't make sense. And then if there are things we can embrace, give some consideration.
Okay, thanks for that. Another question came in, back to EJ. Can you go back to the Chicago map slide? I want to look at the drop-down inputs to EJ scoring.
Yeah, I can do that real quick. And happy to send around. We've got a big EJ slide pack I can send around that goes through all this stuff. Let's see here. Share. Okay. Yep, here we go. Yep, so here it is. There's environmental indicators, and so here are all of them. And you can get this off EPA's website, or you can send you the slides, or I don't know, I've got a bunch of just EJ specific slide packs, but you'll see them here. And then demographics, and I forget what EJ indexes is. And look, for this audience, it's if you have not read the government's complaint in the Lime Tree Bay case, this is the emergency order section 303, you must stay shut down case. I'd suggest you read that. That will give you a good insight into how the government views EJ. It talks about some of these factors, and it's in a specific context. I'm happy to send it around. The other one that you could take a look at, which has been a big headline case, would be the I think it's called RMG scrap metal case in Chicago, where the facility decided to move from the north to the south side, and a deal actually negotiated with the city. But then when they got to the south side, everyone cried environmental justice, and but some of the correspondence there will talk about EJ scoring as well. So those, hopefully, both of those will give you some insight into what's going on.
Okay, I appreciate it, Justin. We're close on time. If anybody else has any questions, this is the last chance. Otherwise, Justin, thank you very much. As usual, it's always a pleasure. And, more to come on this topic.
Thanks so much, Laura, and it's nice seeing everyone, even if only virtually. Take care.
Bye. Thank you.